Good morning, good afternoon, good evening. Hello to all of you, wherever in the world you are. And thank you so much for joining us for this Quadrant Chambers webinar. I'm going to just give it a couple of seconds because I can see the numbers are still jumping by 10 every 2 seconds. We're on 272. Shall I wait to hit 350? Right, let's get going. Whoever controls the sea controls the world. Those are the words of Alfred Thayer Mahane. He was a preeminent US naval strategist who argued in 1890 that global power ultimately turns on control of a small number of strategic maritime corridors, narrow waterways through which an outsized share of the world's commerce must pass. He therefore argued that it was a military and strategic necessity for nations to seek control of these waterways, which they could then leverage for global domination. So the notion that a country could close a key strait as a means of waging a war is not new. And we've seen state attempts to threaten freedom of navigation before, including the Houthis' attacks on ships in the Red Sea and Egypt's closure of the Suez Canal in the 1950s. What is new, however, is the scale and severity of the current crisis, with Iran having successfully closed the world's most important energy choke point. This has already produced the largest oil supply shock in modern history and obstructed crucial supply chains for LNG. In the last 2 days, individuals from both Shell and BP have issued warnings of severe shortages in the next few weeks. And this week, the Philippines declared a state of national energy emergency. There's also a real shortage of fertilizers. According to the UN, about 1/3 of the global seaborne fertilizer trade passes through the Hormuz Straits. Alfred Mahane's words were well understood by analysts and military planners who have long warned that in any war with Israel and the United States, Iran might indeed seek to choke the Hormuz Straits just as they have done. It's been 26 days, and in one sense, nothing has changed. Only a handful of ships, a little bit more, have been through the Straits. In another sense, it's a hugely dynamic situation with ever-changing information and changing landscapes. I mean, take this week. At the beginning, we had a 48-hour ultimatum from Trump to the Iranians, but which was ignored. Yesterday, we heard that a Thai ship had passed through the Straits, thanks apparently to diplomatic talks, but with no money exchanging hands. But then also yesterday, there was news that the Iranians would give safe passage to non-enemy vessels, but in return for a $2 million transit fee. Today, there are reports that Iran has promised the IMO and the UN that non-hostile vessels will be allowed through. And just as we were waiting to come onto this webinar, we saw on the news a report that Israel has apparently blown up Iran's naval chief, that the defense minister who was in charge of arranging the blockade and having the mines dropped into the Straits, that he has been killed. So there may be significant change coming as a result of that. In the meantime, thousands of ships are trapped with tens of thousands of seafarers on board and with millions of dollars worth of oil and other commodities. And many more ships are not physically trapped, but they and their cargoes are in limbo unable to reach their intended contractual destination. Unsurprisingly, we have had a wide-ranging number of legal questions in relation to shipping, commodities contracts, energy contracts, and insurance. And with me today to discuss some of these urgent issues are three of my colleagues at Quadrant Chambers, who are now, as if by magic, going to unmute and unvideo themselves so that I can introduce you to them. Hi, guys. So let me introduce you to Chris Smith, Steph Barrett, and Lydia Myers. And you'll see that we have here a range of legal calls, ranging from the ancient to the leading KC to the senior junior and the junior junior. But with each of us and many others here at Quadrant, having been answering a lot of urgent queries over the last few weeks. As always, though, the devil is in the detail, the specifics of the particular chain of contracts and issue, the specifics of the particular clauses at hand, and the specifics of the fact pattern. However, we do hope to give you an overview of some of the legal approaches to the problems arising. Before I hand over to our speakers, just a little bit of housekeeping. The session is being recorded, and you will all be sent a copy of the recording in a day or two. There is also somewhere on your screen at the bottom a question and answer function where you can type out a question. I think only the panel will be able to see the question, and we'll try and answer some of them if we can. But we make no promises because there are an awful lot of you, and we just might not be able to get through the questions. More housekeeping. When a speaker is speaking after this, I'm hoping that you can see all four of us right now. But, and if you can't, send a question through and tell us there's tech difficulties. But what's going to happen is that when a speaker's speaking, the rest of us are going to switch off our cameras and our mics so you see just them, save that I will occasionally be doing the webinar equivalent of a photo bomb and swooping in suddenly in the middle of a speaker's monologue to ask them a question and to keep them on their toes. So look forward to that, guys. I'm now going to hand over to Chris Smith, who's going to focus on some of the energy issues arising, including, I think, how the legal concepts of frustration and force majeure could play out. So, Chris, I'm going to switch off.
Thank you, Poonam. Hello, everyone. Yes, so I'm going to be looking at frustration and force majeure. I'm going to be doing it through a bit of an energy lens. Now, there's probably for at least some of you a bit of a sense of deja vu here, taking us back to 2022 and Russia's invasion of Ukraine, which gave rise to very similar questions relating to frustration, force majeure provisions, and the like. Perhaps surprisingly, there's not, at least within the sectors that we all work, a single reported court decision as to if and when the war in Ukraine was a frustrating event. So, notwithstanding everything that happened 4 years ago, we don't necessarily have a great deal of further legal guidance. Anyway, to start off, I'm going to say a few things about the effects of the closure of the Strait of Hormuz, just to set the scene for some of the potential arguments that might be raised as regards frustration, force majeure, and the like. So, as we know, the Strait of Hormuz has been closed, and that means that shipping activity has virtually stopped. I say virtually because some ships carrying Iranian oil to China have apparently been allowed to come and go. Now, via the Straits of Hormuz, some 15 to 20 million barrels of oil used to transit every day. That was a fifth of the world's oil supply. Equally, a fifth of the world's LNG supply was transited before the war via the Strait of Hormuz. Now, for a lot of the operators within that within that geographical regime, this is a disaster. Saudi and the UAE have a degree of protection. There's an east to west pipeline across Saudi Arabia to Yanbu. That's capable of transporting 5 million barrels a day. There's also a pipeline from Abu Dhabi to Fujairah, which is capable of transporting 1.5 million barrels a day. But that just amounts to a quarter of the total amount of oil that would otherwise go through the strait on ships. And on top of that, those are just the countries that are connected to pipeline systems. Iraq, by contrast, has no link to a pipeline system. So you've got all this oil and LNG that can't get through, which is affecting both the suppliers of those cargoes, but also the receivers all around the world. On top of that, there have been attacks on infrastructure. As you probably read, on the 4th of March 2026, Qatar Energy had suffered some attacks on their infrastructure, and they're a firm that's responsible for 20% of the global LNG supply. They declared force majeure on their short-term contracts after some attacks on their facilities. The immediate result of that was that the price of natural gas spiked by 50%. And obviously, the LNG price review lawyers who were listening in were presumably quite excited about that. Now, that was in early March. On the 18th of March, there was then an attack on the Ras Laffan production hub in Qatar. Those attacks damaged 17% of Qatar's LNG capacity, and it's estimated the repairs are going to take 3 to 5 years. And so, as a result, Qatar Energy have stated that they're going to need to declare force majeure, not just on their short-term contracts, but now on their long-term contracts. And this could be for a period lasting up to 5 years. On top of that, Qatar had some plans to expand its LNG exports, do work on the infrastructure, a project that was due to start, I think, in 2027, and that project now has been inevitably delayed. You might ask the question, well, Chris, can things get worse? The answer is, well, maybe they can. So there's two pipelines I mentioned earlier. Well, Iran is aware of them, unsurprisingly. On the 9th of March, there was an attack by a drone on Fujairah, and there were reports on the 19th of March of an attack on Yanbu. So it's potentially the case that the supply via those pipelines is going to be interrupted. And then finally, on top of all that, you have the Houthis. They've so far refrained from joining the war, but if they do so, if they decide they want to back up Iran and start causing access issues in the Red Sea, then we're getting quite close to a perfect storm territory. Anyway, so that sets the scene for some of the points that are going to rise in this regard. But in light
Chris,
of that, I want to make a few quick points about frustration and force majeure.
Chris, can you see me?
Yes.
Photobombing you early because of the first question that we've been asked. I think I said the Hormuz Straits has been closed about 5 times. You said it 3 times. I was aware of this issue when I was writing, but one of the questions is that one of the key issues that the industry are looking at is whether the strait is closed for the purposes of insurance. And indeed, I've had this point come up over the last few weeks in relation to a commodities contract. I have had a view and I've expressed a view on it because some of the ministers, in fact, I think it was an English minister last week, who said it's open, it's not closed. And so the Iranian and the US Secretary of War said it's open, it's not closed. But what is your view as to down the line what a court might conclude as to whether during the last few weeks the straits have been closed?
My understanding of the position on the ground is unless you are a ship carrying Iranian oil to China, the Iranian forces have made it clear, subject to the 2 million payment point you mentioned earlier, which gives rise to a couple of issues on frustration, but I can maybe discuss that in a bit. Subject to that possibility, if you try and sail, if you're an ordinary commercial ship, you're not carrying Iranian oil to China, blah, 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 and you try and sail through the Straits of Hormuz, there's a risk that you're going to get bombed, mined, or attacked. Uh, and if that's right, and obviously there are risk analyst firms out there who can tell you what the position is, but if that's right, then I think the idea that the straits are open in any real practical sense for the kind of contracts we're talking about is just simply not the case. I think, practically, if your contract requires a ship, a carrier of some sort, to go via the Strait of Hormuz, the information on the ground is you will be bombed or attacked if you do so, then that strait should be regarded as closed for these purposes.
Well, I'm pleased to say this was an actual live question we got 2 minutes after you started speaking. It's not one you and I have ever discussed before, but at least you're confirming that the advice I wrote earlier this week wasn't wrong. I will switch off and let you carry on now. Thanks, Chris.
All right, and I hope you meant right. Frustration. I'm not going to talk to you about the test for frustration in any detail. Everyone knows it. Supervening event, no fault by either party, performance impossible or fundamentally different. It's not enough if performance is just more expensive, less profitable, blah, blah, blah. Normally, in the context of frustration, you're looking at one of two things. Impossibility, ideally, if you're trying to argue your contract has been frustrated and it's impossible to perform, or that's the gold standard. But for here, where we're talking about the closure of the Strait of Hormuz, for the most part, it's going to delay performance. You can have frustration by delay. It depends on a variety of matters, the nature of the contract, the envisaged length of performance, and the remaining length of performance for the obligations that are still to be done under the contract. Now, a key element here is the perceived length of the delay. There are some very old cases from the 19th century when people were riding into battle on horses that said that for the purpose of frustration, war can be presumed to likely to continue for so long as to frustrate the commercial adventure. I don't think that'll be the position now, and especially not with the third Gulf War. Poonam mentioned how fast moving this has been. We had Trump threatening to bomb power stations if the strait was not reopened within 48 hours, only last weekend. Trump didn't follow through with that, but whilst the 48-hour period was running, it could have been said that, well, there is a real possibility that the strait will reopen in the near future. So you can't have any frustration by delay. Earlier this week, there have been mixed messages as to whether or not there are talks going on with the regime in Iran, with the suggestion coming out from the Americans that there were talks underway for a complete and total resolution of all hostilities. Nothing's happened yet, but it's very clear that the position is volatile and unpredictable. It's certainly more unpredictable at this stage of the war than the position was in the Ukraine conflict. By early to mid-March 2022, it was pretty clear that Ukraine and Russia were going to be in it for the long haul. I don't think any seasoned or knowledgeable observers at that point thought, well, there's a good chance it could be over in a week. Here, we simply don't know. There is a real world in which this conflict stops and the Strait of Hormuz opens for shipping in the relatively near future. We just don't know. Now, one of the points that arises in that context is, well, how can it be said if a contract is going to be frustrated in such a volatile situation? Obviously, this is a context and contract specific question. You have to look at the consequence of the delay for any contract. Take Egypt. Egypt is a net oil importer. It also imports a third of its LNG needs from Qatar. For a country like Egypt, it can't necessarily afford to wait 2 months, 3 months, or even maybe 4 weeks just for its LNG to turn up, and it may need to make alternative arrangements. Contracts of that sort, therefore, where you have as an essential element of the contract performance in the near future, in the first half of March, for instance, there seems to me there's probably a decent argument they've been frustrated. However, because of the volatility of the position, I suspect for the vast majority of contracts, parties are going to have to adopt a wait and see approach. They may not be frustrated yet, but they could be so in the not too distant future. Now, one of the points that Poonam mentioned in her little bit at the beginning was the fact that Iran was going to allow potentially certain vessels to transit the Straits if they paid a transit fee of 2 million US dollars. Uh, it could be said then, well, hang on a second. You can get through the Straits of Hormuz. They're not closed. You can just pay the money. And can it be said as a result of that, well, it can't be a frustration if the contract is merely more expensive to perform or less profitable. And so therefore, any ship now in a position where they could simply pay the 2 million and get through cannot claim that there's frustration, or equally any other contract which is consequent on a ship getting through. That's an interesting point. The party calling for performance of the contract in those circumstances will say, well, you've got to pay up, it's just more expensive, so there's no frustration. My personal view is I don't think the position is clear cut. Let's say I agree to sell you a painting. The painting is then stolen by a gang of thieves, and the gang of thieves say, right, I will return this painting to you if you pay us a 2 million ransom. Can it be said in the circumstances, therefore, that the sale hasn't been frustrated by the theft? I can still perform the contract, it's just a much less profitable one for me now. There's going to be 2 million off my bottom line as a result of the fact that I have to pay the ransom. In my view, it must be at the very least highly questionable whether a court would say, no, the contract is not frustrated because the seller should pay the ransom, or at least the fact that a ransom can be paid prevents the contract from being frustrated.
And
There are a couple of arguments you could raise in this regard. It could be said, well, when asking, is it just a question of expense to perform? You have to look at the normal expenses. And this exercise or analysis is limiting to just to identify are the sums that are being required to pay to perform it normal or foreseeable ones for this trade. Obviously, a ransom can't be said to be normal or foreseeable. Equally, it might be said there's a public policy argument here against the payments of ransom, and the court wouldn't want to say encourage parties to have to pay ransoms by saying the possibility of a ransom means that your contract can't be frustrated. Anyway, so I think the demands by the IRGC, if they're saying pay us 2 million, you can come through, could be likened to that. And so the possibility of such a payment uh, shouldn't turn the dial so far as frustration is concerned. That's
Thanks,
frustration.
Chris. Chris,
Yes.
related to that issue, a couple of questions have come in. One was, if they did pay the transit fee, would owners be able to recover that from charterers? Well, I'll give you my view. And another one was, well, what about the diplomatic negotiations that people are having? Again, one of the questions was, do we know how you go about that? I don't think anyone on this panel does know how you'd go about starting that diplomatic discussion, but if any of you do, put your cameras on. But so can ransom fee be recovered from charterers under the guise of being a transit fee? And also, the question was asked, can it be said that it's an implied term of the charter party that owners should seek to negotiate with the diplomatic channels to get the transit? While you're thinking about that, on the transit fee, I don't see that there's any world in which what is in reality and understood to be a ransom could be recovered from charterers unless the charter party had some specific provision that literally covered that sort of piracy ransom sum. But otherwise, no. Chris, do you agree with that?
Yeah, well, the argument would be absent express term, take a time charter that, well, it's part of the implied indemnity. That's a sum the owners have incurred as a result of complying with the charter's orders. And in a purely factual causation sense, that would be right. So the question is this the kind of risk that the owners or the charterers have agreed to bear the burden of under the charter? And most charters these days have kind of war risk provisions, piracy provisions, things like that, all of which envisage potentially the payments of ransom. So in those circumstances, I would say it's unlikely, if I was asked to give a gut view, that you probably could get the ransom from charterers under the implied indemnity in circumstances where your charter has a war risk, piracy, so on regime in the BIMCO clauses or the like. But equally, it seems to be well arguable. You'd certainly give it a go if you're in the charter, sorry, in the owner's shoes, just simply because there is the element of factual causation there. You can show a direct line from the orders to the payment of the ransom, and because for the most part there won't be anything in your charter saying nope, charterers aren't to pay that. So it'll be a question of implication as to who's bearing the risk.
Okay, well, we can be instructed on opposite sides of that debate. Um, any thoughts on the implied term on the diplomacy? Otherwise, I'll leave you to get on with the rest of your talk because I've been interrupting you too much time-wise.
No worries at all. No, to be honest on that point, no real thoughts. I don't know for a fact what the exact mechanism or procedure would be. That would seem to be impact on whether or not there's an implied term in that regard, because he assumes that the mechanism or the procedure that can be used in this regard is one that's easily accessible to the ship owner, that they can just call up someone or other. And it's harder to imply a term if the ship, if Iran said, well, we'll do it for 2 million, but it's not clear how you pay that 2 million. How can a ship owner be under an obligation in that regard if it's not clear exactly what has to be done so as to make the payment? So I think it's problematic personally, but it raises obviously quite an interesting point. Right, moving on. Force majeure provisions. I'm going to be reasonably brief on force majeure positions because provisions, sorry, because these are all very much fact clause specific. It's going to very much depend and turn on the terms of the clause themselves. Points to look out for is whether or not your clause refers to performance being prevented, so impossible, or just hindered. Obviously, hinders makes it easier for the clause to be engaged. The other point I would make in this regard is some clauses apply just to foreseeable events. Now, that means that a force majeure provision in a contract concluded before the Third Gulf War is probably going to be applied differently to one in a contract concluded after the Gulf War. So, for new contracts post 1st of March 2026, just beware that point. Um, final thing from me, and then I'm going to hand over. I just want to talk about the interplay between frustration and force majeure. Now, most sophisticated commercial contracts contain a force majeure clause. The question that arises is, does the presence of that clause preclude reliance on the common law doctrine of frustration? The answer to that is no, not absolutely. There is a question to be asked as to whether the contractual clause makes quote unquote full and complete provision for the events in question. And it's been clarified as a case called the Florida that this must mean full and complete provision for the effects of the event in question. Now, one relevant factor here is whether the clause encompasses circumstances that fall short of frustration. There's quite a few clauses, war risk clauses, piracy clauses, which refer to a party being entitled to do X or Y, depending on their judgment and/or perception of the risk. Well, the fact that one party perceives they're a risk can't be a frustrating event. For frustration, there has to be the risk or the relevant event. And so, if you have a clause which seems to cover a situation falling short of frustration, that would seem to me to suggest that it doesn't make full and complete provision for the events in question. And I would also finally suggest that one needs to distinguish here between terms which provide liberties to one or other party to perform alternatively, or terms that provide practical solutions that problems might arise. That type of clause isn't, in my view, full of complete code because it's not seeking to comprehensively address liability and the question of whether the contract continue to exist in the meantime. But these are all questions which are going to be explored by the courts, by arbitrators, and by the lawyers in much greater detail over the coming weeks.
Thank you very much, Chris. There have been tons of questions arising out of some of the things you've discussed, but we're going to have to move on. And a lot of the questions that are being asked are very fact specific. How long till it will be frustrated? What if you had this clause or that clause? So we can't really get into all the detail of that. Instead, I do need now to hand over to Lydia, who's going to come on next. And Lydia is going to cover a group of discrete legal issues that we've all been consulted on over the last few weeks. Lydia, over to you.
Thanks very much, Poonam, and thanks very much, everybody, for joining us. So I'm going to deal with three topics that myself and colleagues have been asked to advise on, specifically in relation to the Voy War and the Con Wartime clauses, both the 2013 version and the new 2025 versions of those clauses. I'm going to briefly deal with triggering the clause, with who pays the premiums, and then bills of lading and discretion not to sign and what happens as a result of that. So I think there's probably three takeaways, certainly from my section, and that is, if you're triggering one of these clauses, it's all a matter of timing and context. We've seen from both Poonam and from Chris, this situation is constantly evolving, and the moment that the decision is taken to go or to not go or to deviate, albeit not an uncontractual deviation, is really important. The second takeaway is that paying the premium doesn't mean that you take the protection. So I'm going to quickly discuss the Supreme Court decision in the Polar in that regard. And then as a more sort of rounded takeaway, specifically in the context of time charters, if we have a chain of charter parties, then if we're not back to back, then we need to take real care. So the area has been designated a warlike operations area, but I'm sure that we all have experienced that the availability, scope, of cover is obviously unstable. So obviously that means we're going to have disputes. Everybody's familiar with Con Wartime and Voy War. I don't tend to go through those provisions in this context. And there's also standard provisions that we've seen disputes arise under, including under the Aspertank Voy Charter Party pro forma as well. It's not apparent that every ship that we're being asked about is working on the basis of the BIMCO 2025 clauses, because naturally some of these charter parties have been agreed prior to the update to those clauses. But there are some changes in the 2025 versions which clarify previously confused issues, or where there had been disagreement between the courts and some of the practitioner texts. So it is worth checking which version we're working on and how that affects things. The clauses broadly confer a right not to proceed to an affected area, an area affected by war risks, and provide for reimbursement of expenses of proceeding to an alternative discharge port. Generally, these clauses can be overridden by other clauses, and that's why always we have to construe the charter party as a whole. If there's a clause dealing with a particular area or a particular risk, such as in the past we've seen clauses dealing with piracy that have overridden war risk clauses, but also if there's a specific clause dealing with a conflict in or around Iran, then obviously that's going to take precedence because that's a more specialized clause. Long story short, it depends on the charter party as a whole. There is a tension as concerns hire between Con Wartime 2025 and the previous version, in that there was the case of the Captain Stefanos, which seemed to provide that the off-hire regime would remain in place despite a war risk provision, hence it being important, again, to construe the charter party as a whole. But some of the authors of practitioners' texts, such as Time Charters, thought that that might have been wrong. The situation has been clarified in the most recent version, and even if you're not working on the basis of a 2025 version of Con Wartime, which provides that without prejudice to the off-hire provisions, the vessel will be on hire, even if you're not working off that version of the clause, it does show the intended direction of change. And so that's probably a good idea of how the court would interpret the older version of the clause as well. So dealing with engaging the clause, it's not triggered by the existence of war. So just because we all agree that there's a war going on doesn't mean that these clauses are coming into effect. What's relevant is the quality and the immediacy of the risk that's being posed. So the question is whether the master judges that there's a risk of exposure to danger, with considerations of good faith and reasonableness. Poonam, you photobombed. I'm wondering if you've got a question.
We've had some questions about, well, what does reasonable judgment mean? How high is that threshold? I'm not, off the top of my head, aware of any authorities on that per se, but surely the fact that I think you said we all agree this is a war and it's that's going on, that is going to mean it's very unlikely that anyone's going to say that a master has unreasonably concluded that there is a danger or that it's not safe, that the very fact of the war and the dangers that have happened would make it pretty easy for a master to pass the test, no? Or is there something different in the detail?
It's definitely affected by war risks. I think we all agree on that. But the problem is as you've emphasised and as Chris emphasised, the situation is constantly changing. There's different information available literally within minutes. This talk has been updated as many times as we've had days this week, because initially it looks like there's going to be a ceasefire, then it looks like there's not going to be a ceasefire. Will the situation change if there's a ceasefire and the master hasn't yet made his decision whether to go or to not go? And that's the problem.
Presumably the specifics matter. So, for example, could it be said that the master of a ship that's carrying Iranian oil could not reasonably conclude that there were dangers because he's one of the safe ones because he's carrying Iranian oil?
No, it absolutely depends on the specifics of the ship. If there's a US connection, then obviously there is a heightened and more imminent risk, and that decision not to proceed is probably one that is quite safe. If the vessel is closely connected with Iran, then yes, you could argue that does decrease the risk on your example if it's carrying Iranian crude oil. But there are examples, and as we've seen over the past few weeks and in the past month, of also Iranian ships being targeted. We've had the seizure of the Venezuelan tanker by US forces. And so we're not just looking at the threat from Iran, we're also looking at the retaliatory threat from Israel and from the US as well. There's been a lot in the news, I think, about shadow fleets and how they're profiting and coming out stronger than ever from the war. But in actual fact, most of those vessels are loading at Karg Island, where Trump is increasing the presence of ground troops. So those vessels, even if they're not part of the shadow fleet, which is problematic for other reasons which are outside the scope of this talk, if they're going there, then there's probably a heightened risk for those ships as well. That's why it's just so important, as in Chris's case with force majeure and frustration, that there are constant updates from the ground being received, and special emphasis from certainly legal advisors here if the situation is not appreciated, that we gather evidence and document the basis of decisions that are being made. That's going to avoid the later skirmish over whether the master was in fact acting reasonably or not.
I'm going to let you go in a minute, but on that last point that you made, it's very interesting seeing all the various questions that are being posed. And I'm sorry the audience can't see them all, but because different people are expressing quite different views. There was one comment 10 minutes ago of lots of ships are getting through. There is a clear procedure in place for how you can get clearance and go through. And another one who's saying, how can we pay any sort of transit fees to Iran? They're sanctioned. Even the very payment of monies would be sanctioned. So even amongst our attendees, they seem to have very different experiences of just how feasible it is or isn't to get through. Right, I'm going to let you carry on and go away now. Goodbye.
No worries, thanks. So that deals with triggering the clause. That's all I propose to say on that. Then dealing with the premiums question. So the US International Development Finance Corporation, which is a mouthful on a good day, has pledged 20 billion US dollars as a maritime reinsurance plan. That's aimed at getting things moving again. So obviously, if you're pledging that plan, that suggests that you don't think that things are moving, but I'll leave that there. Chubb, for example, has said that it will be a partner in that package and will make the maritime insurance facility available to ships transiting the Strait. All of that to say, I think a lot of people are worried about insurance getting pulled. But actually, more of the disputes, certainly that I'm seeing and colleagues of mine are seeing, is that it's not that insurance isn't available, it's just at a huge cost. So is it too much in terms of cost, and is it too little too late, and who pays? Under the Common Wartime 2025 clauses, if the vessel does proceed or remain in an affected area, the charterers will reimburse insurance costs and the additional premiums. Insurance cost is now defined in the terms, adding some much appreciated clarity there. And it's not my intention to read out the BIMCO explanatory notes, but there is quite good guidance from BIMCO on those clauses. Under the VOI clause, if the owners affect the war risk insurance, then they pay for it. But if the vessel proceeds through or remains in the affected area, the charterers will reimburse that cost. What is clear from the 2025 version and codified previous case law on the issue is that it's actually only costs that are actually incurred that are passed on. And that's the cost that the registered owner of the vessel pays to their insurer in order to get those extra premiums. So it's not the case of a flat fee which is being passed down, and it's not the case of caps being passed down. It's only that initial cost that is allowed to be passed on. And indeed, there's requirements in the updated version of the clause that requires greater transparency, and that's one of the themes of these updates. So owners, head owners or registered owners have to show that they have got insurance on terms that they say they've got it on, and they have to show what extent they took steps to try and reduce that insurance, etc., etc.
It's me again. So one of the questions that's being asked is about caps. As you say, additional war risk premiums are available, but just at significantly more. In my experience, before the war broke out, it was a part of a percent, 0.25% of the hull value was the sort of premium. Now it's more like 3% or even more. Some charter parties, etc., have caps in them. So I'm going to pose you a question that's arisen, which is: imagine that you've got a head charter and the obligation is on charterers to pay the additional war risk premiums, but with a cap of 200,000. Assume there's a subcharter where the subcharter party has an obligation on the subcharterer to pay head owners' premiums in the usual way, which have to be vouched, but there's no cap in the subcharter. And assume there's the premiums of 300,000 for the sake of argument. So head owners claim against charterers, they pay only 200,000 because they've got the cap. Charterers then claim against subcharterers. Do subcharterers have to pay just the 200 because that's all the intermediaries pay, or are they on the line for the full 300 because that is head owner's premium? And if so, who gets to keep the extra 100K? Do this as briefly as you can, Lydia, because we're overrunning terribly.
Yeah, no, it's a good question. It's not clear. I don't have a definitive answer for you. Beyond, it would seem to me, on the basis of the updated clauses, that the 300,000 that head owners actually paid would be what subcharterers need to pay. That, I would hope, would be more uncontroversial than the question as to what happens with the extra 100. Instinctively, it seems unfair for charterers in the middle of the chain to take advantage of their cap and also pocket the 100 grand and say, I'm keeping that. But I'm not sure what the basis of the subcharterer's liability to head owners would be. So on what basis that money would be claimed by head owners.
Move on from that. I think it might be even an implied term, right? That you're paying the head owner's insurance premium on the implicit understanding that that is what's going to be rebated to head owners.
Yes, quite. But no, I don't think that the cap could be passed down. Whether the cap actually applies on the wording of the clause is another question. What's interesting, and I mean, I'll end on this, is the Supreme Court decision in the Polar. So I'm sure people will be aware the vessel was seized by Somali pirates in the Gulf of Aden. The ransom was paid and general average declared. Cargo argued they had no liability because the voyage charter contained an insurance code on the basis of the Voy War provision and other provisions, which would have the effect whereby you'd only look to ship owners' insurers for liability. That was then to be incorporated into the bill of lading so that cargo could rely on it. The main thrust of the judgment is no, there's no such code. That decision's been codified in the 2025 explanatory note, where BIMCO says, to be clear, even if charterers you pay for this premium, you are not afforded the protection of the insurance unless you're a co-insured. It depends on the construction of the charter party, obviously, but there's no prima facie position that the insurance provisions amount to a code, qua the Ocean Victory, and there's no rule that the charterers can take advantage of insurance unless they're a co-assured. Finally, in the Polar and in relation to voyage charters, again, it was held that the war risk clause couldn't be relied on in that case because there was no qualitative change in risk after conclusion of the charter party. So even though in con wartime there's a provision which says owners aren't taken to have assumed the risk just because they agreed at the time of the charter party to go to Iran and the war was taking effect, in the voyage charter scenario, there needed to be a qualitative change in the risk level after the conclusion of the charter party. So if you agree the charter party yesterday and there's no change in the risk level today, arguably on the basis of the Polar, then you can't rely on the war risk clause. Poonam, I was going to speak about bills of lading, but actually it might be best if we leave that and then see if there's any questions.
You can have 1 minute on that because I've also
give me 1 minute.
Yeah, because funnily enough, charter parties I've got 2 cases where charters have been concluded since the war, knowing of the risks, but in one of them, they haven't issued a bill of lading yet. So go on. What happens if people don't issue bills?
Fine. My whistle stop tour. Voyage charters, you can refuse to sign the bill of lading if after loading it appears you're going to be exposed to war risks. That's clear from Voy War. That's uncontroversial. What's interesting is in the event that that bill of lading is not signed, what happens to freight? Usually freight and freight being earned and freight being paid are 2 things which are effectively bifurcated in the charter party. So freight is earned on loading, but it's payable on issue of the bill of lading. The critical date is when freight is earned, because there's authority to the effect that once freight is earned, it becomes an accrued debt, and therefore you can request payment. The right to freight is also expressly preserved by Voy War, so I would be comforted if you have a provision which says freight is earned on loading and you've loaded, that you'll still get your freight, even if you discharge elsewhere, because your right to freight is preserved. In the time charter party scenario, there's no equivalent right not to sign the bills of lading. So it's arguably a repudiatory breach to refuse to sign. It might therefore be advisable to sign and then recover losses under the implied indemnity, but there's not scope to consider that here.
I'm not giving you time for the implied indemnity. So that is something that Steph might touch upon in her whistle stop tour. Steph Barrett's up next. And the other issues she's going to talk about are safe ports, about which we've had lots and lots of questions, and also redelivery. Steph, over to you. You've still got time. You don't have to rush too much.
Thank you, Poonam, and good afternoon to everyone. Yes, I'm speaking about the charter party issues that Poonam has outlined, although I know that there are many more other issues out there. Right, so safe ports, firstly. The key point with this is that these are prospective warranties, so timing is absolutely critical. So the safety is judged based on the situation as at the date when you nominate a load or discharge port under a voyage charter or under a time charterer, the date when you give the order to proceed to that port. It does look ahead to the time when the vessel will be there, and it does take account of reasonably foreseeable changes in conditions, but the safety is being judged from the perspective of the position as at the nomination or the order date. Now, note that ports are usually nominated earlier than berths. Berths often nominated on arrival at the port. So make sure you are judging your question of safety as at the right date. But in either case, it's not a continuing warranty of safety thereafter. So I think it's good to think about this in terms of some different scenarios. So the first scenario is where you have an order to proceed to a port given pre-war, and the war breaks out after the vessel gets there. Now, this will depend on the precise circumstances as at the date of nomination or order, but if at that date the port looks safe, it's probably a case of supervening unsafety that is not a breach of a safe port or a safe berth warranty. See the key case, that EVIA number 2. Or you could put it another way and say the war is not characteristic of those ports until it breaks out, or it's some sort of abnormal occurrence. So the second scenario is your charter party is pre-war, but you nominate a Persian Gulf port after the war breaks out. Now, although the circumstances are changing all the time, whilst the war is still on, then this probably is unsafe, probably is a breach. And time charters says that a port could be unsafe following a declaration of war. You might be able to use a lot of these ports in safety, but you can't really reach or depart from them without being exposed to a risk of danger.
Steph?
Yes, Poonam.
He's not going to get away long without a question. So on that point, and again, we've had some questions about different ports within the Persian Gulf. A lot of the ports are themselves perfectly safe. There's no danger surrounding them. The local difficulty is that you have to go through the Straits of Hormuz to get to the ports. And for the reasons we've discussed at length, that doesn't feel like a safe thing to do. So how does that work in the unsafe port analysis, the scenario I've just posed to you?
Yeah. I think the fact that the Straits are quite far away from some of these ports doesn't prevent them from being unsafe as a matter of law necessarily. I mean, from my perspective, there have been attacks at ports and at sea all over the Persian Gulf anyway. I don't think the issue is narrowly confined to the Straits. But even if it is, the port safety warranty covers the approach to the port. And we know from cases like the Saga Cobb, a risk of attack on the way to the port can be evidence of unsafety. And there is no strict limit in the cases in terms of distance. In particular, there's a case called the Mary Lou, where in that case, they found New Orleans to be unsafe because of danger about 100 miles downstream at the mouth of the Mississippi River. And the reason that far away obstacle was attributed to the port was that it was the only way in and out. And I think the key question for Mr. Justice Mustill in that case was, is there an alternative route to get to your nominated port? If there is an alternative route, then that port is safe. But if there is no alternative route, then the route is potentially covered by the warranty, the safe port warranty. And of course, the analogy to our case is obvious. You know, the Strait is the only way in and out of these ports unless you're coming from or going to another Persian Gulf port. Now, what I've just said goes for safe port warranties. It doesn't hold true for safe berth warranties, though. You're far less likely to be in breach of any sort of safe berth warranty because a safe berth warranty doesn't cover the safety of the approach to the port. And it also doesn't cover risks that affect all berths at the port equally. So, scenario 3, you nominate a Persian Gulf port, but then pre-war, then war breaks out before the vessel passes the strait. Then, again, supervening unsafety, you're not in breach of your safe port warranty. But under a time charter, there is a secondary obligation to nominate an alternative safe port if the first port becomes unsafe. Unclear under a voyage charter. The textbook voyage charter says probably no obligation to renominate, and they say you should look at frustration in those circumstances. As Lydia's briefly mentioned, owners might have a liberty to change loading or discharge ports under com wartime, voy war, and there are also other potential liberties and rights not to obey orders, for example, where the master believes that that order exposes the vessel to risk. There is another provision you often see in voyage charters which says the vessel to proceed to export also near there to as she can safely get, or that sort of wording.
Popped
up again.
Yeah, sorry. We've had loads of questions that are far too specific for us to answer. What if we went to a port that was west of the Straits? What if we went here? But link to that and to the point you just made, where you've got a liberty to choose another port or to go to export, the one you just said in the Aspertine Voy. Export also near there to as she may safely get.
Yes.
I seem to be obsessed with distances today. How far away can you be? I mean, can you say, well, I can't get there, but the nearest I can get is the port 50 miles away. That's the safest I can get. So is that good enough, or is there some limitation geographically or characteristically or something?
Yeah, there is a lack of clarity on this. There's one case called the Athamas where the liberty was exercised to discharge 250 miles away, and the Court of Appeal said that's okay. Here, we may be looking at even greater distances than that. And the Court of Appeal in the Athamas said, you do have to apply reasonableness to the distance. And at some point, the distance might be so great in relation to the duration and the nature of the contractual voyage and the adventure that the substituted port cannot be assumed to be within the contemplation of the parties. Now, that's a very unclear test, doesn't give you a lot of certainty, but certainly, 50 miles looks to be all right, that sort of distance. Thousands of miles, who knows? If you went to the nearest safe port outside the strait, and you've got a nominated port inside the strait, my instinct would be that you'd be all right. If you instead took her all the way to Japan or Australia or something, then no. But in between those, there's room for doubt.
All right, let me let you get on. Let's try and cover, we must do redelivery.
Yeah.
So see whether, are you doing implied indemnity next, or?
I can do implied indemnity in 30 seconds, maybe.
All right, go.
So if you're not in breach of your safe port or berth warranty, can you recover under the implied indemnity? Now, some controversy as to whether you can run this as an alternative to have a different result. Time charters, some cases say yes, you can. Problems you're going to have are, is there something else in your contract which is going to allocate the risk of the relevant event, war risk clauses, etc. Second problem you're going to have is causation. What you need is for the initial order to go to that port to be the effective cause of the loss. Now, it needn't be the only cause, but if it's just a but-for cause and the war comes in and it's obviously a sufficiently dramatic event and has a lot of causal sort of potency to it, is the order to proceed to that port, is that still the effective cause of your loss? That's the issue I think is going to come up in the implied indemnity cases. So pleadable, possible, but difficult. So
let's move on to redeliveries, because I know this has happened a lot. I mean, what we've got ships hanging about with charterers paying lots of hire in circumstances where the voyage that was contracted for and the duration should have been completed a long time ago, but charterers can't get the vessel out of the Gulf because they're not transiting through the Strait. So what a lot of charterers are asking now is, can they redeliver now in the Gulf to stop the bleeding of paying hire? The Persian Gulf is not within the redelivery range. It's not one of the contracted ones, but what's our advice? Should they go ahead and do that?
Well, I mean, they can do it, put it that way. You can redeliver even if you're in the wrong place, but it is a breach. And in one case, the Rhine, it was thought to be a repudiatory breach. the interesting questions that then arise are about what the damages are for that breach. So the usual measure of damages is what owners would have earned on a ballast voyage to the nearest port in the redelivery range. And from that, then you deduct any actual earnings that owners have during the period when that would have taken place. And this is the way you calculate the damages, even if the final voyage would have taken you beyond the maximum charter period. Now, on our scenario, it's potentially more complicated because if, for example, a ballast voyage to the nearest contractual port takes 3 days, do you just award the hire for those 3 days minus any actual earnings? Or do you take into account the time that the vessel is going to be sitting in the Gulf waiting for the strait to reopen before the ballast voyage starts? Now, there's no case law on this, but I think it's the latter, because what you're looking at is the counterfactual. What would have happened had the charterers performed their redelivery obligations? And if the case is that the vessel would have been sat in the Persian Gulf and then carried out a ballast voyage, then that looks like the right counterfactual for damages purposes. Does that mean the charterers are going to pay higher for the entirety of that waiting period as well? Prima facie, yes, unless they show that the vessel would have been off hire under one of the off hire clauses in the contract. Now, as Poonam said, this is on the basis that the Persian Gulf is not within your redelivery ranges. If the Persian Gulf is within your redelivery ranges, then you should be fine. Unless that you have wording which qualifies your redelivery provisions, like safe port and no warlike zones. And I have seen cases where people have added that into, for example, clause 4 NYPE. Again, no cases on this. But again, this is like redelivery in the wrong place, in my view. The geographical range is being qualified. So you can redeliver, but it's a breach. And what you've got to do is an assessment of the facts on the ground as at the date of redelivery. Right now, today, is this port safe? Is it in a warlike zone, etc.? So it's not a prospective warranty case. You don't really apply the cases on sort of supervening unsafety or whatever. You're assessing safety as at the redelivery date. And again, the measure of damages is going to be like redelivery in the wrong place, and you're going to have similar issues, similar problems arise. So my last topic, and I've got 2 minutes, is off-hire. And I will do this really quickly. Just depends, obviously, on your specific wording. If you've got calm wartime 2025, owners might be in a better position. Depends what service is required next. So if you're loading, discharging, waiting at anchorage for those operations, you're still on hire. You're still performing the service. You need to get to a point where you can't perform the next service. You are very unlikely to be off hire under a standard clause 15 NYPE. This is extraneous to the physical condition of the ship, crew and cargo, unless your vessel is actually damaged, of course. If you add whatsoever to the standard NYPE clause, then it's arguable that you're off hire. Another possible argument for charterers is if you have an off-hire clause which covers detention or something similar than that. Now, the Iranians are not arresting vessels, but the definition of detention in the cases is very broad indeed. One issue that's going to come up is charterer's fault exception. Delay caused by charterer's fault is not off-hire. This doesn't require an actual breach, but it does require a causal link between the time lost and something done or omitted by the charterers. Unfortunately, we're back on causation again. And as ever, we bear in mind that the burden of proof on charterers is to bring themselves within an off-hire clause. If you have any ambiguity whatsoever, it will be construed in favour of the owners. That's all I was planning to say. I know it's been a whistle-stop tour, and there are lots of other issues out there as well. But I hope that's been helpful.
Thanks, Steph. On detention, actually, there's one thing I wanted to mention because we've had some questions being asked about insurance policies. The definition of detention in the charter party context is surprisingly wide. I'm just going to read you a quote. From one of the cases was, if there is some physical or geographical constraint on a vessel's movement which prevents her from proceeding on the course directed by charterers, the fact that she is not prevented from proceeding elsewhere does not negate detention. So that's very apposite for where we are now. And it's also clear law that the meaning of detention and restraint of princes in the context of a bill of lading contract, a charter party contract, or an insurance policy are unlikely to be different. But the word of caution that I wanted to raise here is that you may have a detention under a charter party or a commercial contract, but not have a detention under your policy of insurance because of this. Imagine a ship that's waiting to go into the Gulf. So she's waiting to go to a port that requires her to go through the Straits. She might be detained within the meaning of a charter party because she cannot proceed to the place that's directed by charterers. But she's unlikely to be regarded as detained within the meaning of the insurance policy because there's no risk or peril that is currently acting on the vessel. The vessel's not going to go through the Straits of Hormuz because she wants to avoid the peril. She apprehends there will be that peril. But she is not, while she's deciding not to go in that peril, she's not being detained within the meaning of the policy. So there are these subtle differences between the insurance context and the charter party context. Right, can I ask my other speakers to turn on their cameras so that I can thank them very much. And you, although you can't do a round of applause from over there, can also send your positive vibes of thanks. And can I, on behalf of all of us, thank you very much all for attending. There's been over 400 of you on this with so many very interesting questions. Thank you, and we wish you all the best with all your disputes and an early, well, not an early, but a quick end to the Iran war. Thank you all very much.